All right, so I just want to say hello and welcome. My name is Bree with Madison Credit Union. We're so glad that you could join us for today's webinar on wills and trusts. We're excited to have attorney Gregg Auby here with us. Gregg is a shareholder at Laffey, Sabranek, Auby, and Risto SC, where he focuses on estate planning, probate, and trust administration. Over the past 30 years, he's helped thousands of individuals and families create thoughtful estate plans and navigate the process of settling estates. He's also been recognized as a top-rated attorney by super lawyers, so we know we're learning from one of the best. Today's session is being held both in person and virtually. If you're joining us online, feel free to drop your questions in the chat. We'll be keeping an eye on it throughout the session. Otherwise, we'll also have time for a Q&A at the end where you can ask your questions directly. And just a quick reminder, we are recording today's session, so you'll be able to watch it later or share it with others who might find it helpful. With that, let's get started, and please join me in welcoming attorney Gregg Auby.
Thanks, Bree. I appreciate that. Thanks for the opportunity. Thanks to Madison Credit Union. So a couple of preliminary things that I usually mention when I give a webinar or a seminar. One, this will be incredibly boring if it turns into a lecture. So I would invite those, especially those present here at the credit union, if you have questions, just raise your hand or interject for that matter. I'd rather be more of a discussion than a lecture. I think people will find it more interesting. That said, sometimes when people interject, they forget that there are others present and there is no attorney-client privilege or confidentiality in this setting. So maybe think twice before you ask your question, because you may be betraying personal information. Either that or preface it with, I have a friend who has this issue or something. So with that, we'll go ahead and get started. So the first question I often present is, why do I need an estate plan? That seems like a logical question to ask. When I came out of law school 32 years ago, I was at a presentation where the professor said, and I've hung on to this all these years, if you don't have an estate plan, the state has one for you, which I thought was clever, but true. So if you do not have your assets titled in a particular way, or beneficiary designation structured in a particular way, or a will or a trust, we're going to talk about all those different estate planning methods. If you don't have that, the state has default statutes that dictate what happens to your assets and accounts when you pass away. We call those the intestate statutes. And essentially, it's a next of kin assessment that's done under the statutes to determine who, in the absence of specific guidance, would receive your estate. In isolated circumstances, that is consistent with what the client wants, but in isolated circumstances. So obviously, given what I do for a living, I would recommend that you're more proactive in that area, and that you, if you don't already have an estate plan, that you create one. Guardianship laws come into play if you do not have advanced directives. And by that, I simply mean healthcare power of attorney. Most of you are probably familiar with that document. Financial power of attorney. If you are in the hospital and unable to make your own healthcare decisions or your own financial decisions, or you're incapacitated for that matter, and you don't have an advanced directive in place naming someone you trust to make decisions on your behalf, then the state has a statutory framework for that as well. And it's not a very appealing one. I've been through guardianships, maybe you have as well. A family member typically has to petition the court to be their loved one's guardian. There are multiple attorneys involved, because what the state would call the ward, the person who's in need of a guardianship, would have potentially their own lawyer. They would have a guardian ad litem representing their best interests. And the person petitioning for the guardianship typically has an attorney. So rather than pay 3 attorneys at $350 to $500 an hour to have someone appointed your guardian, it's usually best to be proactive in that area as well. Obvious reason for an estate plan is leaving assets to loved ones. I think that's what people commonly think of when they think of an estate plan. We just talked about planning for incapacity, making sure you name someone you trust to make decisions for you. If you have minor children, the way in which you would nominate guardians, physical guardians for them, would be in a will. That's the only document that you can use in Wisconsin to nominate guardians for your minor children. And a big one, especially in probably the last 15 to 20 years, is to minimize court involvement. And we're going to talk about that in more detail. Obviously, tax considerations. That has, believe it or not, become a little less important for my client base because each of you sitting here today has a $13.99 million estate tax exemption at the federal level. When I came out of law school, it was $600,000. So that's changed quite a bit. The big, bold, beautiful bill, which I shall not comment on political effects of that. The big, bold, beautiful bill, I'm probably not even calling it the right thing. That established a $15 million estate tax exemption starting next year. And then that's adjusted upward for inflation every year from there on. That was especially pressing for Congress this past summer because in the absence of legislation, those tax cuts would have expired to the end of the year. So there was a lot of uncertainty in my world as to planning. Given the much higher estate tax exemptions, we're doing a lot less estate tax avoidance planning than I was doing 32 years ago. And I just think, and this may sound a little hokey, but I've always felt like estate planning is good stewardship. Now I see it on the front end and I see it on the back end. So when I'm working with a family of a loved one who had a well-established estate plan, it makes the family's lives a lot easier and they appreciate the fact that their loved one took the initiative to create the plan. In the absence of a plan, I see just the opposite typically, and it could lead to arguments among family members and frayed relationships and things that can't be remedied. So I'll throw good stewardship out as a reason for estate planning as well. So we talked about why. Let's talk about what. So what is an estate plan? Traditionally, the cornerstone of an estate plan was a last will and testament. We still do wills these days. I still have clients who have wills as their primary estate planning document for reasons we'll discuss. So that's one document that you typically see. It could be a simple will that just says, when I pass away, everything goes to this particular person or these particular people, and here's who the executor would be. You see a lot of wills as the main estate planning document in the context of clients who have minor children. Because if those clients, husband and wife or partners, or if those clients pass away without an estate plan, the court will determine with the guardian ad litem's assistance who the guardians would be of the minor children. In a will, as we talked about, you nominate who you wanted to be the guardians. Those guardians get appointed through what we call the probate administration, the probate process. So clients with minor children will often come into my office and be surprised that I will recommend against establishing a revocable trust and then paying me thousands of dollars, and rather establishing wills with what we call testamentary trusts. And this is a very common planning technique. My wife and I had this until recently. My wife and I have wills that say if something happens to one of us, everything to the survivor. We have 4 children. Something happened to both of us. There would be 4 separate but equal trusts established, one for each of our kids. We name who manages the trust for the benefit of the child. The child has access to the funds per the trustee's discretion for their health, education, maintenance, or support, which is a customary, call that a HEM standard in my world. And then when the child hits a certain age, they get entitled to the principal.
So the virtual one, they're not seeing this.
Oh, they aren't?
No.
That's interesting.
So let's see.
So I think I'm sure. I didn't do that right.
So this is the one you're sharing right now. So
Okay.
hear that
Try
one.
that one.
Or
Maybe that's going to be my monitor. That's going to show me twice.
here, how about this?
Try that one. I apologize. As lawyers are prone to do, and I got gabbing, and then I.
No, it's okay. It took me a little bit too watching them.
All right.
Hi. Perfect timing. Right.
So hopefully everybody online, hopefully you're seeing my very artistic slideshow that I set up for tonight. So that's what a testamentary trust is. So we have clients typically who have minor children would have what we call a testamentary trust. A trust created under a last will and testament. So that's why it's called a testamentary trust. Now I'm not going to be able to move it forward because I'm not sharing my screen. Let's see here. Here we go. We talked about naming guardians for minor children in a will. You can have language in a standard will that allows you the right in the future to create a separate written list of personal items that might have sentimental value to you and who's to receive those items. And if you have that boilerplate language in your will, you can sign that separate list without the need for witnesses. So that's kind of a nice feature that's been around for about 15, 20 years. It empowers the client to take control over distribution of personal items. Now here are two big takeaways. If you don't remember anything from today, these are the big issues to think of. In doing this for 32 years, I'd probably say 95% of the estate planning mistakes I've seen revolve around these two issues. And they seem very obvious. I'm sure they'll seem obvious to you. Any accounts that are jointly titled with another individual, when you pass away, they automatically, by operation of law, go to that surviving joint owner. So it's not uncommon at all for married couples to have the lion's share of their assets are held jointly, especially bank accounts. So if my will says one thing, but all my accounts are jointly titled with somebody else, the joint ownership comes first. That's the very first thing you look at before you ever get to a will or a trust. Similarly, most people have beneficiary designations on life insurance retirement accounts, or they should, for reasons we'll talk about. And it's become very common, in the trend in the United States right now is to allow beneficiary designations for everything. You know, you can put beneficiary designations on your bank accounts. You can put beneficiary designations on individual stock holdings. You can put it on real estate now in Wisconsin, which you couldn't do until about 15, 20 years ago. Yes.
Do those then supersede probate?
They do.
Yeah,
They
good.
do. So that absolutely right. So for people online, the question here was, if you have a jointly held asset or a beneficiary designated asset, does that avoid court involvement when the time comes? And the answer is yes. So that's a really potent estate planning technique. But when you're doing your estate plan, you need to be mindful of those two areas, because I think a lot of people just jump to creating a will, creating a trust, and they don't think about how the assets are titled or how the beneficiary designations are set up.
So if you have a beneficiary designation and a will that has a list of who you want to go where, the beneficiary would say that person can decide what they want to do with it?
Absolutely. Yeah. And let me give you an example. I was just working with a client this week. And the client came in with a will that said, very basic will. It just said, when I pass away, I want everything to go equally to my 3 children. Okay. And the client wanted to change that and put a $200,000 bequest in for Wisconsin Public Television. Fantastic. Okay. But in further questioning the client had the 3 children as the beneficiaries of every account. So what seems counterintuitive, we have to remove some of those beneficiary designations for there to be $200,000 in the estate in order to satisfy that bequest. Because again, the beneficiary designations, when the time comes, would just be equally to the 3 kids. Even though the will says $200,000 to Wisconsin Public Television, there's not $200,000 in the estate. So just an example of being really careful. I can give you worse examples, like client comes, this isn't one that I was particularly working on, but client comes in and says, I have 4 adult children, one of whom I haven't seen in several years, and for personal reasons, I just don't believe I have a relationship with this child, and I want to disinherit them, quote unquote. So attorney drafts will trust to make it very clear that that child is disinherited. And then lo and behold, when the client passes away, my children are the beneficiaries of the largest asset in the estate. That child's getting their share. So it's just something, though, like, as I said, those 2 areas, if you walk away with nothing else today, those are critical areas, not only from the standpoint of making sure that things are going where you want them to go, but as you mentioned, it's a probate avoidance opportunity. If you have responsible adult beneficiaries, and there are some additional caveats we'll talk about as we go through.
Maybe I ask another question.
Sure.
Does the beneficiary designation then supersede or take precedence over what's stated in the will?
Yes.
Okay,
Yes. So often when I get a call from a nominated executor in a will when their loved one has passed away, and we call that a person representative in Wisconsin because we have to be different. I will say, first of all, I'm very sorry to hear of the loss of your loved one. Take some time to focus on the funeral arrangements if there's going to be a funeral. But then when they come in 2 or 3 weeks later, we walk through this order. So the first question is, all right, here's a bucket of jointly held assets. Those automatically go to the surviving joint owner. Here's a bucket of beneficiary designated assets. Those automatically go to the beneficiary. If they aren't in the first 2 buckets, that and only that is will, trusts, and tested statutes. So something to really be mindful of. I mean, I've worked with, excuse me, I've worked with clients who've been married for 20 years and they forgot to take their parents off as the primary beneficiaries of their life insurance. Which that could get sticky. I say something with it. So something to think about. And so as you work with your estate planning attorney, that's something to be mindful of. Most experienced estate planning attorneys will have a questionnaire of some sort that will ask for that information and or they will ask you for that information as during the representation. It's very important. I've kind of been talking about it as an aside, a revocable trust. I'm going to get into revocable trust more in detail in a few minutes, so we're going to skip that for right now. But the reason you might do a trust or consider doing a revocable trust is to avoid court involvement when you pass away, what we call probate. The nice thing about a revocable trust is while you're alive and you have complete control of the trust, it's disregarded as a separate entity for tax purposes. So a question often comes up, well, great, if I do a trust, does that mean now I'm going to have my accountant prepare a trust income tax return? The answer is no for that particular type of trust. There are other types of trusts that are kind of outside of the scope of today's discussion, but when you hear of a friend or a family member having a trust, don't just assume that it's one particular type of trust. This happens all the time. Clients will come in and say, well, I have a friend who said I really need this. And I say, well, we're not a one size fits all proposition. Let's talk about your objectives and let's look at exactly what would be the best type of estate planning vehicle to use for you. So, but we have irrevocable trusts, we have life insurance trusts, we have charitable trusts. We talked about testamentary trusts. That particular trust that we'll talk about in more detail later is what we call a revocable or a living trust. We talked about advanced directives. I would say advanced directives would include a healthcare power of attorney. It could include what Wisconsin calls a declaration to physicians, which is more commonly known as a living will. A healthcare power of attorney, you're saying if I can't make my own communicate my own healthcare decisions and 2 doctors have signed off on that after personally examining me, here's the person I trust to step into my shoes and make healthcare decisions consistent with my wishes. So it's a very powerful document. You're delegating your decision-making authority to someone you trust. A living will, on the other hand, the Wisconsin's form declaration of physicians is 2 pages, I think. It's just, I don't want feeding tubes. I don't want artificial nutrition, hydration. Those, more of a directive to the physician as to what your wishes are. A healthcare power of attorney, frankly, is more powerful. It's if you can't make the decision, here's the person who can. Wisconsin has, we talked about financial powers of attorney. Wisconsin has a relatively new, and in my world, that's 10, 15 years, a relatively new advanced directive, which you might consider incorporating into your estate plan. And it's called an authorization for final disposition. So leave it to the legislature to come up with a warm and fuzzy name for the document. Authorization for final disposition. What it allows you to do is to name someone to make funeral and burial arrangements for you and or to specify what you want when the time comes and to give it force of law. So it's nice. It was a document that really came into being because the courts were ill-equipped to handle the issue of cremation or no cremation. If you Google Wisconsin advanced directives, your search will more than likely take you to the Wisconsin Department of Family Services. I think they're still calling it the Department of Family Services. And you can actually find fillable powers of attorney and this particular document in fillable format. With my clients, I usually have them use the fillable form through the state. I don't usually have them use the state financial power of attorney as an aside, but if you're interested in this particular document, you can get at it just by Googling Wisconsin advanced directives. We talked about those. Marital property agreements, not going to spend a lot of time on these, but people are sometimes surprised to know that there are some tax reasons that you might have a marital property agreement. And we call those opt-in marital property agreements that we typically use in conjunction with a revocable trust-based estate plan. Trying to avoid capital gains taxes. Instead of it being what I brought in as mine and what you brought into the marriage or the relationship is yours. Instead, an opt-in is it's marital. And in those cases, you want it to be marital, and I'm going to get in the weeds a little bit with some tax law here. One of the best deals we have going in the tax code right now is if you have an appreciating asset, real estate investment. I'm not talking about IRAs or 403Bs, 401Ks. I'm talking about just traditional investments that's appreciated, hopefully, over time. And you're married, and it's classified as under Wisconsin law as marital property, and this opt-in marital property agreement would definitively say it is. When the first spouse passes away, whatever the value of that investment or asset is on the date of death of the first spouse, that's the new starting point, or what the accountants call cost basis in the hands of the surviving spouse. So the example I would give, and I usually use my arm, I guess people are seeing my arms on the screen. I'll try to fit it in the screen. If you acquired stock for $100 a share 30 years ago, and you're married, and when the first spouse passes away, it's worth $1,000 a share. What would have been taxable if you had sold it during both spouses' lifetime, it's what's called a step up in basis to $1,000 per share in the hands of the surviving spouse. So the surviving spouse could sell those shares after the first spouse's death and pay zero capital gains taxes. And then when the second spouse passes away, hopefully it's appreciated again. It gets a second step up in the hands of the beneficiaries of the estate plan. I'm shocked Congress hasn't taken that away from us yet. They've talked about it over the years. It's connected to the federal estate tax legislation. But I don't think people online were hearing this when we were talking about it before you came online. But when I came out of law school, you could give to your loved one $600,000 free of federal estate tax 32 years ago. Sitting here today, you can give $13.99 million free of estate tax. If you're married, double that. So if you're married, you can give, it's kind of ridiculous. 28 million free of federal estate tax. So those exemptions have gotten much higher. We have very few clients who are subject to federal estate tax, but rather than take away the step up in basis, Congress has left that alone. So from a tax perspective, as a taxpayer, and we can debate the merits of whether this is good for society. From a taxpayer's perspective, that's as generous as the tax code has been in my 32 years of practice of law. So an opt-out, oh, sure, sorry.
So, but if you hold that stuff jointly, then you don't have to worry about it. But if it's held in one name, you can avoid it by beneficiary?
It depends. For the step up, it depends. Wisconsin's marital property law went into effect in 1986. So if you acquired investments during the marriage and after that date, it probably is defaulting to marital property. Where things get complicated is what you had mentioned. What if they're in just one spouse's name? What if you lived in Illinois for 20 years and moved to Wisconsin in 2007? So what this opt-in marital property agreement does is it definitively says it's marital. It gets the basis step up. And in case anyone questions that, IRS, in an audit, you have the marital property agreement to shut the audit down and just say it's marital. But that's a good question. Yeah, the default is marital for married couples, but there's exceptions to that depending on where you've lived. Wisconsin is one of 10 marital property, or what we call community property states. The other community property states are on the West Coast for the most part, in the Southwest. Arizona's community property state, Florida is not. California is, New York is not. So you have kind of a hodgepodge of rules when it comes to these tax-related estate planning concepts. So something to talk to your estate planning attorney about.
And
Yes.
does that Is marital really a word in that? Like if you've been partners, are you still married?
No, it's marital.
It has to be marital.
It is, yeah. Um,
I used that, my husband passed and I stayed in the house for 3 years and it was way too big for me, so my daughter bought it and I did that.
yep,
So she could, it was easier for me.
yeah, and you didn't have to pay any taxes on it.
No, I didn't have to,
That-
but I have the thing for it, we had to file it.
Yep, the
Yes.
1099 title company files it.
Cause I
Yep.
built a different, house, smaller.
Yep, yeah, so it's a really effective tax minimization technique that you should be aware of. Wisconsin does not, I should say, and I think it's later in the slide deck. Wisconsin does not have a state estate tax. We do not have a state inheritance tax. Some states have both. My brother practiced law for years in Washington, DC and lived in Potomac, Maryland. And Maryland has both a state estate tax and a state inheritance tax. We do not have that, so you don't have to worry about that. We briefly had a state estate tax in it was like 2004 to 2007, and we no longer do. So. Estate planning, your attorney should be looking at beneficiary designations and retirement benefits. So that's something that's critical. Spouse and only spouse can roll over benefits into their own traditional IRA. And not take distributions depending on what your current age is, from age 73 to 75, used to be 70, 72, actually used to be 70 and a half. The Secure Act has been pushing that, and Secure Act 2 have been pushing those age limits up. It's something to look at. Life insurance, important to look at, again, from an estate planner's perspective, look at the beneficiary designations, because that's a key piece. And then long-term care insurance, you don't see as much of the traditional long-term care policies around anymore. Maybe some of you got lucky and got a policy before the market exploded. Or you got something from John Hancock that says you need to pay us 3 times what you were paying us in premiums. 10, 15 years ago. But there are financial planners or financial advisors out there now who are selling products that are kind of hybrid life insurance, long-term care. You can maybe accelerate the death benefit of your life insurance into your lifetime if you need long-term care. So something just to talk to your financial planner mainly about. But your estate planning attorney would probably also be interested in knowing about that. I do not do elder law. So if questions come up regarding elder law, I know just enough to be dangerous and know that I need to refer it to another attorney. But an elder law attorney would definitely be interested in knowing whether or not you have long-term care insurance if you're trying to do some divestment planning to get on medical assistance. Estate taxes, we've been talking about that. An estate tax and an inheritance tax, what's the difference? An estate tax is a tax on the estate before it goes out to the beneficiaries. An inheritance tax, Maryland, Indiana, some states have an inheritance tax. Inheritance tax is the recipient, the beneficiary is taxed. And typically the percentage that they're taxed depends on how closely they're related to you. And I'm not going to go into detail on that. So, because we don't have that in Wisconsin.
Is it more the closer you're related? Or?
It's less the closer you're related.
Okay.
Yeah. So good question. We don't have a state estate tax. We talked about the federal estate tax. You can leave as much to your surviving spouse without there being any tax. You can also now, and this wasn't the case until about 10, 15 years ago, you can transfer your unused exemption, which is what happens more often, to your spouse. So instead of I pass away and we do all this planning to take my share of the estate and set it aside for my spouse to make sure that there's no estate taxes when my spouse passes away, my estate planning attorney and or accountants can file a very simple estate tax return, and my $14 million exemption can be transferred to my wife, and now she has 28 million. We're not going to have any issues there. Just say that just as an aside. So, there's the applicable, what we call the applicable exclusion amount federally in 2025. Pretty mind-boggling in my world. Ways to avoid estate tax. I'm not going to go into great detail about that because if you're like me, you're not going to have to worry about it. Which is, but we used to use a certain type of trust to avoid estate tax when we had lower exemptions. You can make lifetime gifts to bring your estate down. The tax limits on that, and maybe just a quick aside on that, Everybody thinks of this 10,000 a year per person per year. That's now 19,000 per person per year. And what that signifies is how much you can give to someone in any given year without even having to file a gift tax return, which is a Form 709. So my wife and I can double that because we can do what's called gift splitting. We each have 19 million. My life would be laughing hysterically right now. Where is the 19 million? We each give 19,000 to each of our 4 kids on an annual basis and not even file a gift tax return. Some people will come in and say, well, I'm staying below that threshold because I don't want to pay any gift taxes. You can give 13.99 million during your lifetime, or as a married couple, 28 million, and not pay any gift taxes. The significance of the 19,000 per year per donee is the filing threshold. So just to clarify that, because sometimes people don't understand that and they want to make a gift of a larger amount, but not pay tax, and they're comforted to know that they can do that. They just have to have their account prepared. They get tax return to report it to the IRS. Revocable life insurance trust. I'm not going to spend a lot of time on that. That was a technique that I have maybe 2 of those I've done in the last year. Avoiding estate tax, taking life insurance proceeds outside of your taxable estate. That's a way of doing that. And then any amounts that you give to charity are exempt from estate tax. So that's a really excellent way to avoid estate tax if you have the problem of having over $14 million. So this is what I really wanted to focus on more so today. Still, I'll have clients come in and we'll spend the lion's share of our initial conference talking about this issue. Should I have a will-based estate plan or should I have a trust-based estate plan? And like everything else, it depends on what your estate planning objectives are. The advantages of a will, one is that wills are very simple to set up, relatively simple. So again, you could just have a will that says, when I pass away, here's who the executor is, and here's where I want the assets to go to, typically using percentages. Doesn't have to be that. And that will is good as long as it's been signed in front of 2 witnesses. If it was done 50, 75 years ago, it's still good. It doesn't have a termination date. That's another question that comes up. I'm not advocating that people leave their wills in place for 50 years.
Are there, if there's in your will, like, do they have the addresses of the people that you give? Do you have to make sure those are current, or?
You don't have to worry about that. That's a good question. Because really what any estate plan document is taking a snapshot of what the facts were on the date that you signed the document. So if clients, and this happens all the time when you've been practicing as long as I have, I'd say probably 50% of my meetings these days are with people coming back after, I did their estate plan 20 years ago. And that's a common question. Our kids' addresses have changed. Do we need to update the documents? If that's the only change, the answer is no. You don't have to worry about it. Yeah. Wills are, I'm going to put relatively inexpensive in front of that. That was a joke. So wills take less maintenance over time. We'll talk about trust. And for a trust to be working properly, you really have to be very conscientious about how you're titling your assets and structuring your beneficiary designations. With a will, it's not uncommon for people to put a will in place and put it on the shelf and take it off the shelf every 5 years to look at it. But, sometimes, and this is going to seem like heresy to some trust attorneys. Sometimes it's not a bad thing to have the court involved in monitoring an estate. For example, when you have minor kids, you may want the possibility of having a trustee being monitored as to the money that they're distributing for the benefit of the minor children. It's not, I'd say it's less often than not, but sometimes court supervision is not a bad thing.
What do you mean? So you would indicate that in your will?
If you're using, yeah, good question. If you're using a will, the will by its very nature is subject to court administration.
Okay.
So, if sometimes what happens if a client intends to name a fiduciary executor, a bank, they'll go ahead and they'll allow that estate to go through probate because the fiduciary, in that case, the bank, is taking a 2% statutory executor commission, which is what an individual would take. So there's really no downside in that instance to having a bank handle that role. Maybe they don't have a close relative that they can rely on to handle things. But in that context, maybe the client wants the court to be an extra layer of supervision and set of eyes. That's definitely the exception to the rule. Usually if you can keep the court out, that's a good thing. Disadvantages of a will, probate administration. Probate's kind of taken on a nasty connotation over the last 10 to 15 years. But you know, probate court involvement in Dane County, Wisconsin, it's all electronic filing. It's fairly simple.
Yeah, my brother passed away and he just had a sheet of paper and gave it to his son and signed it. And it cost them $30,000 before it done.
Yeah.
Yeah.
So here's and there were attorneys, and that was attorney's fees. That was attorney's fees.
Yeah.
Yeah. So the problem, and I'm going to speak ill of my brethren and sisters. So I'll disavow that I said this. It's being recorded. Yeah, the problem with probate is not so much the filing fee. The filing fee in Wisconsin is 0.2% of the inventory probate estate. The problem is the attorney's fees. So, you know, again, you have an attorney billing at $375 to $500 to $750 an hour in 1/10 of an hour increments, and that adds up fast. And some individual executors, family members will just say, I'm too busy to handle this. I'm just going to go into the attorney's office and sign a POA and say, you do everything. And I'll sit back and relax. And then they get their 13-page invoice. And so, surprise. Yeah. So there's an example of avoiding probate is usually a good idea. Ancillary probate is if you own real estate in another state, you have to go through probate in that state as well. So if you own, I'm just going to jump the shark, as they say. If you own real estate in another state, you should really think about doing a trust-based estate plan, because you can avoid probate not only in Wisconsin, but also probate in the other jurisdiction. Florida probate, I can tell you, is to be avoided if at all possible. Maybe it's a numbers issue. So, but Florida probate, believe it or not, Florida attorneys are statutorily entitled to 4% of the estate as compensation.
Oh, wow.
So in Wisconsin, it's unethical to charge a percentage of the estate for compensation. So pretty different ideas of what's fair between those two states. So if you have real estate in another state, you definitely need to be talking to an estate planning attorney. In the event of incapacity, unless you have a power of attorney, the will really doesn't help you so much, because the will only becomes effective when you pass away, as far as administration is concerned. And a will gets filed. So if you have certain things in your will that you'd rather not be public, it gets filed when the time comes. And if somebody has way too much time on their hands, they could walk down to the probate court and then start paging through wills and reading them. I don't know anybody who does that.
So it's filed when you die.
Yes.
Okay.
Yes. They have a mechanism. Good question. They have a mechanism for filing wills while you're alive. I usually recommend against that with my clients because there's a fee, of course. And then if you change the will, there's a fee to retract it and a fee to put it back in. So most of my clients do not file their original wills. They hang on to their original wills. And probate's time intensive, as someone here in the room probably can attest to, on top of the fees. Advantages of a trust. So let me explain exactly what a trust is. And to do that, I'm going to use my parents as an example. And I should preface this with, my mom does not care that I do this. She knows that I do this. I'm not being a bad son. I don't want people to leave the call. So what I did for my parents 25 years ago is what I call a revocable trust. And the term revocable doesn't necessarily, it means they could revoke it, but you don't see that very often. And really what it's signifying is they stay in complete control of the trust while they're alive. They can amend it if they need to amend it. So we created the Alan and Carolyn Auby joint revocable trust. And then I helped my parents connect their accounts in their condo to the trust. What we used to do 25 years ago is we used to retitle everything in the name of the trust. Now you have the option as well of naming the trust as the beneficiary of the account, or the real estate, even for that matter. So set up the trust for them. They created the trust. They're the trustees of the trust while they're alive, and they're the beneficiaries of the trust. So they're everything in that trust, which is kind of odd. My dad passed away about 5 years ago. Everything just stays in trust for my mom. My mom's the trustee. If my mom can no longer serve as the trustee, I'm named as the backup. When my mom passes away, everything's in this trust. It's private. It doesn't go through probate. I immediately jump in as the backup, what we call successor trustee, and I do everything I would have done as the executor of an estate, but without the interference of the oversight of the probate court. That's a trust. Yes.
So, no, my parents are, anyways. When the trustee passes away, what does the executor do? If there's a named executor, or does it all go to the successor trustee then?
Yeah, it depends on the extent to which the trust is what we call funded. So let me give you an example. With my parents, we made sure everything's connected to the trust. My parents with a revocable trust still have backup wills, and your parents do, what we call pour over, like pour into a bucket wills. The function of the pour over will is to catch anything that didn't get connected to the trust and to pour it or sweep it into the trust. Let's say when my mom passes away, we discover that there's a $75,000 CD at the credit union that just has my mom's name on it, wasn't connected to the trust. Then potentially we have to use the pour over will to get that CD to the trust. That in that event, and only in that event, we would have to get an executor appointed through the probate process. So if the trust is working the way it's supposed to work, you just have a trustee. You wouldn't have a personal representative / executor, because that's under a will. Those are two different functions. In a revocable trust context, the person managing everything is called the trustee. In a will context, the person managing everything is called the personal representative of the executor. So if your parents have a trust-based estate plan, the hope would be you never have to get an executor appointed. The only reason you'd have to get an executor appointed is if there's something that got missed and didn't get it connected to the trust. Does that make sense?
So when they pass away, the successor trustee
Takes over.
takes over.
That's right.
Oh,
Immediately. No 2 to 3 week period of time where everything's frozen, like you might have in an estate.
So I was kind of told differently, because we have different people with successor trustee and executor, and
Yeah, as long as it's in the trust,
executor would step in at that point.
not as long as it's connected to the trust,
Okay.
you're okay. Yeah, and I'll say that if I'm contradicting somebody's advice, I don't have the full panoply of the facts in front of me.
Yeah.
So there may be facts of which I'm unaware. So I'm not necessarily contradicting somebody's advice. So yes, so my parents have this trust. They have pour over wills as a backup. We're avoiding probate. We're avoiding probate in other states if there's real estate in other states. The benefit in incapacity is if my mom gets to the point where she can't manage her finances and she has an account in the trust, I can take over even before she passes away. So we have that planning as well in place with her.
Does she have to authorize that?
If she's competent. So if she's not competent as attested to by a physician,
Okay.
then I could take over as well. Good question. Trusts are private, so they aren't publicly filed, which is a nice feature, especially for people who may not have dirty laundry that they want here publicly. And we just talked about it. The trustee immediately takes administrative responsibility without having to wait until an estate's over. Disadvantages of a trust are more expensive. So that's the number one concern. People usually shy away from doing a trust because it does cost more. Most estate planning attorneys charge a flat fee. I do as well. And the flat fee is significantly higher than the fee for doing a will-based estate plan, mainly because the attorney should be assisting the clients with funding the trust, making those connections. Otherwise, it's not working the way that it was intended to work.
And so it's an upfront.
Yes.
Or is it? Okay.
Yeah, for in my practice, it is. And actually, I should take that back. It's something we typically say that the invoice isn't due until the signing appointment. So we don't have a retainer or a fee advance or anything like that. We don't have half due up front and half due at the back end. My partners maybe would say maybe we should. But yeah, no, everything that we do in my practice is when you have your signing appointment, that would be the first day that we would expect.
But there's maintenance costs.
Yes.
That there wouldn't be maybe with a will. So-
Correct. Yeah, because as you accumulate new accounts, as you sell real estate and buy new real estate, you have to be mindful of the fact that you need to make those connections to the trust. So some people do that on their own, other people involve attorneys, and attorneys really, there's a whole spectrum of how attorneys charge for that. So yeah, so there are maintenance costs, and maintenance You need maintenance awareness you have to have it when you're using a trust is your estate planning doc. And there it is. There's a comfort factor for a lot of clients in knowing that everything's, buckled down up front. Their loved ones won't have to go through probate. I guess that was it. That went through that really fast. So, maybe to circle back, and this is a kind of estate planning advanced level. And back to my parents. So my parents had the joint revocable trust. They have the portable wills. They have the powers of attorney. We connected their accounts and assets to the trust. And something about that. We connected their condo to the trust using what's called in Wisconsin a transfer on death deed, which is relatively new. And you should know about this. It's a very powerful estate planning technique. In Wisconsin now, and in many states, you can have an attorney prepare and record a deed that says when you pass away, here's who receives your real estate interest. So I will have some married couples avoid probate without using a trust. Let's say they have one or two responsible adult children who get along with each other. You want it to stay that way. They can name those adult children as the payable on death beneficiaries of their house or their investment property or their recreational property, any real estate interest, by simply recording this transfer on death deed with the register of deeds in the county where their real estate's located. That's a relatively new thing in Wisconsin, 15, 20 years. So I'll have clients do that. There are a couple of caveats in using that technique, best illustrated by my family. When I was a baby lawyer, I helped my grandmother in Florissant, Missouri, use this technique to avoid probate. Really didn't seem like we needed to do a trust, but she was pretty adamant about the fact she didn't want her estate to go through probate. House in Florissant, suburb of St. Louis, where my mom's from. And so we recorded a transfer on death deed. They've had them for 35, 40 years in Missouri. The deed said, when the time came, my mom and my aunt were beneficiaries, so the two daughters, me and my two brothers and my three cousins in Missouri, the grandkids. So when the time came, all 8 of us owned my grandmother's house. You know where this is going. And it's not majority rules. So it took one, maybe 1.5, 2 people. Every decision was agonized. Every last decision was agonized. We have 2 states involved. So in retrospect, looking back on that, was a very valuable lesson for me that maybe that wasn't the best technique to use. And all kidding aside, I will often say to clients, maybe talk to your kids about this technique and make sure that they can assure you that they're going to be able to get along with each other, because the very last thing you want to do in an estate plan is harm relationships. So that's one caveat. Yes.
If you have a transferred property, can you designate a person that is responsible to sell it? And then the funds get distributed as you want.
You can hear the problems with that method. They teach us to play devil's advocate in law schools.
Right.
But these are some real concerns. One is the person you've designated legally in the eyes of the law owns the property.
Okay.
So when they distribute out the pro rata share of the proceeds, they're making a gift that will more than likely exceed, let's hope, will exceed $19,000 per year per donee. And they'd have to file a gift tax return. So that's a complication. The other complication is, and we could play a what if game all day, but what if the recipient all of a sudden gets hurt with divorce papers? What if they pass away? What if, so there's just so much that can happen in that situation. What's better in that situation is to do a trust-based estate plan, name that person in a fiduciary capacity as trustee of the trust, successor trustee, and then they can handle everything. And when they make the trust distributions, it's not a gift. So that's the better way to handle that. Yes.
We co-title our property with right of survivorship.
Perfect. Yep.
That's okay.
Yep.
That's
Joint
still-
tenants with rights of survivorship.
Yeah, it's still valid.
It's automatic transfer. That's right. Now, what you could do is if the two of you agree on who gets the real estate once both of you have passed, is you could then take the next step and record a transfer on death deed that says to this person. But again, that only works in isolated situations when you have maybe 1, 2 responsible adult beneficiaries. Charities don't like being named as beneficiaries of real estate. I can tell you that. I serve on some boards. We don't like that. We don't want to manage real estate and not be able to sell it for 10 years. But yes, to your point, joint tenants with rights of survivorship, that's automatic transfer.
Right,
That's right. As opposed to tenants in common, which is 50-50
right,
is
yeah.
is what we call that. The other thing I wanted to mention, and then I'll let Bree jump in because we might have some questions online. Yes, she's done. The other thing I'll mention is my parents had, back to marital property agreement. If you have a marital property agreement in a trust-based estate plan, that's not unusual, an opt-in marital property agreement, because we talked about avoiding capital gains taxes. The other thing in Wisconsin that you can put in an opt-in marital property agreement is a pour-over provision. We have this really helpful statute in Wisconsin that says that you can direct the ownership of an asset on death to someone or something in a marital property agreement. So my parents have that. So if I discover that $75,000 CD at the credit union that was not connected to the trust, I can take that provision to the credit union and say, per Wisconsin law, that account goes to the trust. So I just mentioned that in case you have a marital property agreement in your trust-based estate plan and you're trying to remember why the attorney suggested you did that, that's why. Those are the two reasons. And do we have any questions online that I'm unaware of?
Yes, we have a
Okay.
few.
Good.
So the first one is, what would be the suggestion for a single person with no spouse or children and less than $500,000 in assets? Is a will or trust better?
It depends. So it depends on who the intended beneficiaries are. If it's one, let's say adult sibling, then you could do a will-based estate plan and use beneficiary designations to avoid the probate rather than pay the attorney thousands of dollars in fees. However, if it's, I want my 8 nieces and nephews, all of whom are under the age of 18, to be the beneficiaries, then you need to give serious consideration to a trust-based estate plan, because that's the only way you're going to avoid probate. And that's in that situation. So hopefully that makes sense.
Another one here, we have, what are the things or questions you should look for or ask when looking for an estate planning attorney? Excuse me.
That's a great question. The first thing I would ask is that the only area that they practice in? Not to knock on general practice attorneys, but there aren't many of them out there anymore, and that would make me a little nervous. So really, look at the person's bio online and make sure that that's their area of focus, and it's not something that they're doing estate planning on Monday and they're doing an OWI trial on Tuesday. That would probably not be a good idea. So I would also look at experience. Now, you have to start sometime. So 27-year-old me would probably be chastising 58-year-old me and saying, wait a second, you can do just as good of a job as 58-year-old Greg can do. But as I've gotten older, I've gotten wiser, I think. So experience is definitely a factor. I would look for somebody who has experience. And somebody you feel comfortable sharing details with, because you're probably going to have some conversations. There's a huge trust factor with any attorney, but especially in estate planning. You need to have a comfort level. Most estate planning attorneys will have a no-fee consultation where you can actually meet with the attorney. Now, don't tell the attorney that I said that, because they don't have to. I'm not in charge of their practice, but so maybe have a phone conversation, or ask your friends and family who they've, if they're local, who they've worked with, and try and get some testimonials from people as to the person's background. Hopefully that's helpful.
All right, we have another one here. How much is an average trust-based estate plan?
I'm going to give you a range. So usually for a single individual, the range would be, I would say probably, and this would include trust, will, powers of attorney, connecting the assets to the trust. I would say the range usually is anywhere from $2,500 to $7,500. For a married couple, I would say the range is usually from $3,500 to $9,500. It depends to a large extent on, whether you're looking at the capital over the attorney's shoulder while you're. No, I'm just kidding. You could do that at our office. We're not on the high end of any of those. But yeah, I'd say that's a good range to think about.
Okay. They also asked, how much is the average will? I don't know if I missed that or not.
Yeah, I would say that could run anywhere from, for a single person, from like $750 to There's probably attorneys out there who charge close to 2,000 for that. What I don't know why. I said that a lot. And then married couple, I would say anywhere from like 950 to 1,500 to maybe 2,000. But again, if you're getting close to the 2,000s for a will-based estate plan, that's a little much from where I come from. So I hope that's helpful, but I can only really give a range of what people typically charge.
All right. I don't see any more questions. If you do have questions, go ahead and type them out in the chat. Otherwise, you can also unmute yourself and ask the question.
And I have some here too, so maybe while people are doing that. Yes.
I was just wondering, if a single person without children dies and they don't have a will, you would, you do, and so what is that, who do they
Yes.
designate to get?
Yeah, so if somebody passes away if the single person passes away without a will, without beneficiary designations, and all the accounts are titled in their name only, so it's the intestate statutes, and it's really a next of kin
Okay.
evaluation. And where you go with that is we don't have spouse,
Right.
we don't have children,
Mhm.
we don't have grandchildren or descendants.
Mhm.
You go back up to parents if they're living parents, and then down that tree.
Okay,
So in those situations, siblings are commonly part of the mix, nieces and nephews. It doesn't, here's a fun word for everybody to take home. It doesn't escheat to the state. I'll have people come in and say, oh my goodness, I need a will as soon as possible, or everything's going to the school fund in Wisconsin. And I'm thinking, maybe that's not the best word. My wife's a teacher, was a teacher, and my mom was a teacher. But anyway, I digress. So you can go all the way up to grandparents and down that line before it
Okay.
leads to the state.
okay.
So very unusual situation where you would see no second cousins, no.
Right.
Yeah.
How big of a deal is it to change the successor trustee?
Simple. You could do a trust amendment, like a one-page trust amendment.
Okay.
Mhm. It's the same execution formality. Usually with trusts, you have a notarized signature of the grantor or settlor, or we call the person. Very, very easy.
We each have wills, and can they be amended simply by us writing up something and then having that notarized and attached to the will?
No.
Okay.
So I'm glad you asked. You would want to either do new wills or do what's called, we have to call things fancy names, or do a codicil. I don't know why we don't call it amendment. You do a codicil, but it's the same execution formality. It's two disinterested witnesses. So I'm glad you asked, because I've seen that before where people get a notarization, and in the context of a will, and it's crazy that we have these differing execution formalities with everything. But with the will, it's two disinterested witnesses.
Okay.
So there's no magic to the drafting of the will itself. It's just that execution formality is solidly in the Wisconsin statutes.
So let me clarify then. So we could put an amendment to the will as long as we had two witnesses.
Yes.
Oh, all right.
Yeah.
So the same thing.
And what you might do from a drafting perspective is reference the earlier wills, just so it's clear.
Sure.
The wills that we signed on December 15th, 2013 are hereby amended, and your
Okay.
amended provisions, to the extent you can actually cite the sections of the original will, that clarifies things. And then make sure that the two witnesses are in the room with you and everybody's in the room together when everything's signed.
We do have a question here. What happens to accounts if a spouse dies and you have an older will only?
So my first question would be, was the account in just the deceased spouse's name? I'm going to assume it was, because if it was jointly held between the spouses, it would automatically transfer to the surviving spouse. It then depends on whether that account has more than $50,000 in it. We didn't talk about this. If the spouse passed away and it turns out, and this happens sometimes, that there was a checking account or a savings account or investment account that was just in deceased spouse's name, wasn't jointly held, no beneficiary designations. If the accounts that are classified as that in total value are less than $50,000, Wisconsin has what's called a small estates affidavit. We call it a transfer by affidavit. The people here at Madison Credit Union are familiar with those. They can be a little tricky on the implementation side. And your heir or surviving spouse takes that affidavit to the credit union and says, I'm the heir, the total value of the accounts is less than $50,000, transfer the account proceeds to me. If it's over $50,000, you've got probate, unfortunately. Then and I hate it when that happens, but occasionally you see that. That just proves the point that you really need to be careful about your estate planning moving forward. Yeah. Hopefully that answered the question. Some of these questions, they're great questions. It's hard for me to answer without all of the information.
That's what we did. We were married, and I was always making the checks up and everything, but for somehow, and we both worked at the same place with the city, they didn't have my name on it. And
Oh,
when
boy.
he was good, he had cancer and went in for the bad surgery. Then we came here and we straightened all that out.
Oh, good.
So it was all in my name, signed papers, and it was COVID, of course.
Oh,
And so we were doing it in the car, but here was very helpful. with
That's
us
great.
and gave us the paper.
Fantastic.
It was like,
Yeah, the more you can do on the front end, the better. Yes.
Wills are very nebulous to me, so can't anyone just download one from the internet and fill it out, and then do they have to file it anywhere?
For to answer the first question is yes, you can do that.
Okay.
I'll come back to that. The answer to the second question is you don't have to file it.
Okay,
You can, but I wouldn't file it. You just need to make sure that the original is someplace where it won't be destroyed.
okay.
Okay. Let's take LegalZoom, for example. My friends at LegalZoom. So I've seen LegalZoom documents. I've reviewed them for people who have come in with them. The documents in and of themselves are usually not problematic. The problem is you don't get all the follow-up about how do we name the beneficiary designations? Let's take the married couple with minor children. We're going to put testamentary trusts in their wills, but LegalZoom doesn't tell you that you then need to go back to your retirement accounts and life insurance policies and name the trust as the secondary beneficiary of all of those accounts. And if you don't, the kids are going to get access to it when they're 18, and the court's going to decide who's managing the money. So it's not so much the document drafting,
Okay.
it's more the advice that you're getting in addition to the document. Yes,
Before legal marriage in Wisconsin between gay people,
yes,
there was registered domestic
Yes,
partnerships.
yes.
Are they considered the same as marriage?
they are not. They are not for a lot of the tax purposes. That's why Obergefell was, for a variety of reasons, was huge.
Mhm.
But yeah, so it's not the same
Okay,
so especially when you're talking about the step up in basis, which is a huge tax advantage for married couples.
sure.
So
Okay,
So for beneficiaries on accounts, you talk about naming the trust as secondary.
Mhm.
You can't do that with wills, right? So-
you wouldn't do it with wills because the whole idea behind naming a
Mhm.
beneficiary is to avoid probate.
Okay.
You'd essentially be taking something that's avoiding probate and dumping it into probate.
Okay.
So,
Mhm.
and I've seen some attorneys do that before, which shall remain nameless. So
Yeah.
that's, yeah. So that's, yeah. All right, Bree, do we have another question?
We do, yes. This person asks, can a credit union or bank be named as an executor, or does it have to be an individual person?
A credit union cannot. That's one of the main differences between a credit union and a bank. But you can name a bank's trust department. Most of the big brokerage firms have their own trust department. Schwab has a very excellent trust department, Fidelity, Vanguard. There are a lot of good trust departments in the area. Bank of Semper, Lake Ridge Bank, formerly State Bank of Cross Plains. I'm going to forget somebody. They'd be mad at me if they did that. Associated Bank, US Bank, BMO. So there are lots of excellent choices locally, but you can name an individual or a corporate. It's completely up to you. A lot of it depends on when you have the conversation with the attorney, what your objectives are and whether you're comfortable or confident in an individual handling those responsibilities.
Bank beyond that is 2%?
For a will,
Or will.
because that's built into the Wisconsin statutes that an executor in a probate administration is entitled to 2% of the
What
inventory.
about the successor trustee if that's?
That depends on how long the trust administration takes. So if it's like a will substitute and it's gonna be a year or two, usually the successor trustee will recommend to the successor trustee that we analogize to the executor role. And we feel safe in recommending a one-time 2%, because we know that's in the statutes. If it's gonna be, my kids need a trustee until they're age 30, and right now my youngest are 15 and 16, then usually what a trust department will do is they'll charge somewhere approximating 1% of assets under management annually. And they'll take that from the returns. So you would hope that the returns would far exceed the fee. It's less than that typically in all of the corporate fiduciaries have fee schedules, and it's something like, 90 basis points for the first 1 million and 75 basis points for the next 2 million and 70 basis. So the marginal rate goes down as the wealth increases. So hopefully that's helpful. But if you're thinking about a corporate fiduciary, they're more than happy to send you a fee schedule. They would be able to provide that too. Any other questions, Bree?
It does not look like it, no.
And I went over, which that anybody betting on that would have been a safe bet. So, well, thank you everybody for being here. I appreciate it.
Yeah,
You
thank
can
you.
tell I enjoy talking about this.
Yeah.
So, yeah. Thank you. Thanks, everybody. Yeah, you're welcome.
Yeah. And so I just want to thank you all for joining us today, both in person and online. A special thank you to Attorney Gregg Auby for sharing his time and expertise with us. We hope today's session helped make the topic of wills and trust feel a little bit clearer and a little easier to approach. If you think of any questions now that we're wrapping up, feel free to reach out. We're happy to connect you with Gregg's office or share additional resources. And then just a reminder, today's session was recorded, so we'll send a link out as soon as we can, so you can rewatch it and send it out to anybody you think will benefit from it. So again, thank you so much for spending part of your day with us, and we hope to see you in a future event.
Thanks. Thanks.